So, Mr. Moran, have you had any thoughts over lunch that you want to follow
I've
through?
no further submissions, so those are the submissions.
Thank you very much. Thank you. Mrs. Selby.
My lady, my lords, I'm going to address you under 4 broad headings. The first is the law on extrapolation. The second is what is the point of principle. The third is standard life's pleaded case on extrapolation. And the fourth is does standard life's pleaded case on extrapolation fall foul of CPR rule 3.4 brackets 2. But my case in a nutshell is that the judge was right. And to be clear, when I say that, that means not only was the judge right in dismissing the applications, but he was also right in making the case management directions that he did. So if I could start on the first topic, the law on extrapolation. It seems we are agreed that extrapolation is permissible as a matter of law, and that's recorded by paragraph 82 of the judgment. I think we are also agreed that there is nothing in principle preventing extrapolation from being relied upon against a professional, quite where you can and can't seems to be the battleground. You'll have seen in the judgment at paragraph 91 Mr. Moran's example of 10 houses built by the same developer in exactly the same way, suffering from exactly the same defects. That was a case where it was conceded that extrapolation could be used. And we had 100 houses this morning in the debate. In my submission, before the court will actually give judgment for a claimant on an extrapolated claim, the key question must be whether the claimant has proved their case on the balance of probabilities. That question is highly fact sensitive and will depend on the available evidence and the extent to which that evidence is before the court. But in my submission, there can be no hard and fast rules about when a claimant will or will not have proven their extrapolation claim. And what I've sought to do in my skeleton is identify relevant factors which the court might take into account when considering an extrapolation claim. That's at paragraph 65 of my skeleton, which is in bundle 1, tab 7, page 108. Now, I would hope that those factors are not controversial. It wasn't something that my learned friend Mr. Moran addressed you on, and I don't know if you want me to take you through the authorities to make good my list of factors, or whether you're happy to work with what's said in my skeleton.
Just give me the paragraph reference again.
65.
Paragraph 65.
Page 108.
Yeah.
Speaking for myself, I don't want you to, but my lord, or Justice Coulson?
No,
My
that's
lord,
fine.
or
I mean,
Justice
it would be fair to say that it's pretty much, other than your maiden name, it's pretty lengthy as a list, including just about everything that could possibly be relevant.
I forgot one, my lord, actually. Oh, I missed one. And I would say this list is not intended to be exhaustive. But going back to Amy and Cumbria, Judge Davis considered that the strength of the case in relation to the sample would also be relevant. And that's paragraph 25.10 of the judgment. That's authorities, tab 7, page 122.
The strength of the case in relation to the sample.
Yes.
What does that mean?
Well, perhaps it's best if I just take you to it. Or be it
Yes, of
quickly.
course. Yes.
So, authorities bundle, tab 7.
And this is your new point.
It's my extra
forgotten
factor.
point, yes.
I should just say while we're on Amy, my learner friend said that there was a pleaded case in relation to each and every patch repair. That's not right. Actually, the situation, if you look at paragraph 1.16 and 1.17 of the judgment, what had happened was the local authority, Cumbria, had looked at a sample of patching and surfacing works undertaken by Amy and tried to extrapolate from that sample across the whole of the patching work carried out by Amy. But just going back to my point at paragraph 25.10, so that's at page 122. Four lines down at paragraph 25.10, the judge said, I accept that in order to consider the extrapolated claim, it's necessary for me to look at some of the individual allegations, because if it became apparent that Cumbry's case was extremely strong in relation to defects, in relation to causation, remedial works and cost, then that might be a relevant factor in arriving at my overall decision on the extrapolated claim. And just to put that in context, there was only an extrapolated claim being pursued in this case. There was not what we have here, the alternative claim, which is for judgment on the sample. And so what the judge did in Amy was he looked at some of the defects in the sample and also considered whether it was appropriate to extrapolate, because if he felt it wasn't appropriate to extrapolate, then there would be no point going any further in respect to the sample.
So it's a question of whether the sample was, to use his word, strong, was a strong enough sample. Is that what
Well, I think what he was actually saying was whether the case, whether it was a compelling case in relation to the sample. So if we just use these patch repairs as an example, if it was a 50-50 call about whether or not the patches were adequate, that might tell you one thing as a trial judge. But if it was overwhelmingly clear that every patch that had been looked at in the sample was completely deficient, that might be more persuasive to a trial judge.
Well, that's the usual evidential rule, is it? Or the balance of probabilities. If you were only 50% satisfied that it was deficient, you wouldn't have got home.
Yes, or 51%.
Yes. But I mean, the thing is, what you're saying is that if there was sufficient number in the sample that established that there was 51 or 52% likelihood of defective works, that's okay. But if there'd never been anything other than the sample and he couldn't get to that, then everything fails.
Yes.
It's as simple as that.
And just remind me, Mr. Selby, in that case, the extrapolated claim failed because, or one of the reasons, it failed because the sample was too small by reference to the claim that they wanted to bring.
That was one of the reasons.
That was one of the reasons. Right.
There were others.
Yeah.
A big one was that it had been said that there was a 95% level of confidence that an analysis of that sample was sound. It was likely to be replicated through the whole pool, and that 95%, that was a statistical piece of evidence, and that fell
Yes,
away
I see.
in the opening.
But that's back to
That's just back
that's back to the evidence as to the strength or weakness of the sampling exercise as such. Yeah. Okay.
And I would also add, just because we've got loss and expense in issue here, that the key factor is the same with loss and expense claims, whether the claimant has proved their claim on the balance of probabilities. Unless the relevant contract provides otherwise, there are no hard and fast rules as to how a loss and expense claim is to be pleaded. And the authority for that is Walter Lilly at paragraphs 486A to C, which is tab 6 of the authorities bundle at page 80. It's in the right-hand column, about halfway down.
What, in the marked passage?
In the marked passage, so if you start at A,
Yeah.
ultimately claims by contractor for delay or disruption related loss and expense must be proved as a matter of fact. And then at the bottom of little a, absent and subject to such restrictions, the claim contractor simply has to prove its case on a balance of probability. B, he concludes there is nothing in clause 26, that's a contractual aspect of the case, which states that the direct loss and or expense cannot be ascertained by appropriate assessments. And then C, it's open to contractors to prove these three elements, and they're the elements referred to in A.
Yeah.
With whatever evidence will satisfy the tribunal and the requisite standard of proof. There's no set way for contractors to prove these three elements. So that's extrapolation at a general level. There's a particular point that comes up about systemic. And the question is, well, does there have to be a systemic breach? And I would adopt the learned judge's judgment at paragraphs 115 to 117, where he said that there's no magic in the word systemic. An extrapolation may also be legitimate in other kinds of cases. In my submission, extrapolation cases are not confined as a matter of law to cases where the breach or breaches are systemic. And actually, if you look from at paragraph 60 of my learned friend's skeleton, they actually refer to systemic or common default or other viable reason to link the two categories of claim. So I think we're actually in agreement on that as well. My learned friend used another phrase in submissions, a replicated breach of contract or negligence. There obviously has to be a link between the sample and the pool. Must be. But it would be wrong for the court in my submission to prescribe what that link should be, because cases where extrapolation might be deployed will not be limited to cases on the same or similar facts to the present. I'm sure this tribunal can conceive of many potential cases beyond those that I might think of. But for example, I'm aware of a dispute that concerned the accuracy of data received in respect of tens of thousands of water meters, where the court directed a trial of a sample of 400 meters. You might use extrapolation on disputes under facilities maintenance contracts, where there is a dispute about the proper price for or the quality of work done on all the call-outs during the lifetime of the contract. Or you might use it in civil fraud cases, where the fraudster obtains bank details of thousands of customers and takes small amounts of money from each account so as to go undetected. So that's why I say you have to be very careful about trying to be too prescriptive. But I do have, and there is a point about Amy and Cumbria where it had been said, I don't know if it still is said, that Judge Davis said in Amy and Cumbria that you have to prove a systemic breach. And that's, perhaps we should just go to that. It's at tab 7 of your authorities at page 147. And it's paragraph 25.104. Now, it has been relied on this paragraph as saying you have to prove a systemic breach, but in my submission, that's not how it should be read. He was simply identifying that the case before him was one of systemic breach. And saying that different considerations can arise where it's not a systemic breach. And just to make that good, so I'm not sure if you're still reading or you're waiting for me. I can carry on. If you just turn to the next page, paragraph 25.107, about halfway down, it's almost right in the middle of the page, there's a sentence that starts, I accept that in those circumstances it is not unreasonable. In principle, for Cumbria to seek to rely upon representative sampling in this case. The key issue, however, is whether or not Cumbria can demonstrate that it is sufficiently representative to enable the court to place reliance upon it, in circumstances where on any view it converts a small number of individual complaints, honest in value both individually and collectively, into a very substantial claim. So in his view, the key issue was representativeness, and not whether it was systemic or not. Now, the other assertion that has been made is that the use of sampling is limited to assessing the true factual extent of any already properly pleaded series of systemic breaches or defects. For example, Mr. Moran said you're going to use it as a defective welding case or something like that. I'm not sure where that comes from the authorities. In Amy, they hadn't pleaded out a case in respect of each and every individual patch. They were trying to extrapolate into the whole of Amy's work. In ICI and Merit, what happened there was the ICI had terminated the Merit, the welding contractor's contract. And one of the grounds for termination was defective welding. And the argument that ICI advanced was that 38% of Merit's welds were defective. And the way they tried to establish that was through extrapolation. And just for your note, the issue is defined at paragraph 9, and it was issue number 3. Sorry, I'll take you to tab 8.
Yeah. Tab 8, page
177. You see issue 3 about a third of the way down.
Yeah.
And then paragraph 77 is at page 204. Where the judge refers to Mr. Millwood. He was ICI's expert. Mr. Millwood's conclusions were undermined. His percentage figure of 38% for defective welds. And the point was, in that case, he had looked at a sample of 412 welds when there was a total number of 28,000 welds on that project. It's quite a good story, that case, but I'm not sure I've got the time to go into it too much.
But the point he's making at 77
Yes.
is that it wasn't that the starting point wasn't representative of all the welds.
Yes.
It was already limited to those which ICI had already identified as being defective.
Exactly.
So the 412 was already a subset.
Yes. And what the judge actually found in that case was the experts generally agreed that on a normal welding job, 5% of the welds would be defective, and he accepted that evidence and applied that percentage for the purposes of his decision. And you see that at paragraph 169 at page 238.
So if you've got 28,000 welds and 5% of them are defective normally, finding 400 welds that are defective doesn't tell you anything.
No.
If you've not sampled them randomly.
So, just on the particular point that I was addressing you, should sampling be limited to certain cases about defects or what was described as a properly pleaded series of systemic breaches? In my submission, there's no authority for that proposition. And more so, there is no reason in principle why the use of sampling should be so confined. As I've said, you can think of a variety of cases where it might be successfully deployed. And certainly the court's case management powers in CPR Rule 3.1 are not circumscribed or limited in this way. Nor is the court's power to control the evidence under CPR Rule 32.1. And that provision, Rule 32.1, was quoted by the judge at paragraph 87 of the judgment. In my submission, there's no magic in defects. Defects are a breach of contract as much as the allegations against BDP are breaches of contract. And interestingly, in the case of Zagora, when Amy and Cumbria were cited to the judge, and I'll take you to the paragraph, the judge found that Amy and Zagora were two completely different cases. So Zagora is at tab 9 of the authorities granted.
Zagora was a defects case.
It was a defects case. Claim, as you know, my lord,
Yeah.
it was a defects case, claim under a new home insurance policy. And the particular relevant issue for present purposes concerned the extent to which there were fire safety defects in the development, the extent to which the steel frame had been fireproofed, and the extent to which cavity barriers had been installed properly or at all. The claimants contended that the defects were universal, but the defendant contended that that case had not been made out. And if you could turn to page 336 of the bundle, at paragraph 10.2.10. Judge Davis, you said...
Hang on a minute.
I'm sorry.
This is in this form because this is part of the judgment that wasn't reported in the building law reports.
Yes.
So this
Or the
is,
ConLRs, I'm afraid.
all right, construction law. Anyway, we have it in a reported form, but it's not complete. So that's why we've got this in Judge Davis's
Yes.
judgment, as it were, handed down to the parties.
Yes.
So, and you're drawing our attention to 10.2.10.
10.2.10 at page 336. So you see at the top that the judge was satisfied on the evidence that the absence of fire protection was universal. But if you go 4 lines from the bottom towards the end of the, you see, although I was referred to my own decision in Amy and Cumbria, where I made certain observations about the proper approach to cases based on sampling, that was a case very far removed from the instant case and cannot be thought to lay down principles of application to cases such as the present.
So why was, just help me link those. I'm sure it's my fault I'm being slow. Why there were fire protection defects. Did somebody want to rely on sampling?
Well, no. So there were fire protection defects. The issue was, had the steel frame been properly fireproofed?
Yeah.
Of course, the claimants hadn't opened up the whole building and inspected every square metre of the steel frame. They had opened up in limited areas, and they had other evidence about the steel frame as it was delivered to site, and so on. And what was cited, well, it was against me because I was in that case, but what was said against the claimants was that the claimants hadn't proven their case properly
Oh, I see.
and the sample wasn't sufficiently representative, and so on, citing Amy and Cumbria.
And that assertion the judge rejected.
Yes, he said Amy and Cumbria is not relevant.
So quite apart from numbers in a sample, in any one case in which the judge has got to make a determination as to whether or not the number sampled is sufficiently representative, as you've indicated in the ICI case.
Yes.
One of Mr. Moran's points this morning was that you've got to look at the nature of the sample as well. So that, for example, in the 4 categories that Standard Life pleaded in this case, it really wasn't good enough to suggest, well, it's one or the other. What do you say about that?
I say there is a real connection between the defects investigated for the 4 works packages and the pool, what I call the pool, the extrapolated variations.
But he goes on to say, well, if that's so, you haven't even said, well, this is in the first category of Schedule 1 or...
The A, B, C, D already.
Yes, yes. So, do you say that he makes a good point there, in terms that the sample has got to be representative of nature as well as number, so that if, in an extreme case, I'm sure the judge would have said in ICI, well, you can't say, that there's 84% of welding that's gone awry, and also that the window catches are all
Yes.
rather substandard. I mean, that seems to be quite extreme, but obvious.
Yes.
But are you saying that there are circumstances where, again, it's a matter of degree, and there is going to be possible to extrapolate a particular negligence or a particular breach of contract that is applicable to a wider, detailed group
Yes.
of deficiencies?
I do say that.
Yes, but it's all a question of degree.
Absolutely.
Okay.
I'll come on to the precise or the reasons why I say there's a connection.
Yes,
in
of
this
course,
case.
of course.
Um,
It's just that I'm just catching up on your nature and number.
Yes, but
nature
absolutely,
and number.
absolutely, you can extrapolate for the purposes of breach, as well as loss, or perhaps causation, or whatever else you want to.
As long as you're not running amok, saying this is either negligence or it's breach of contract or it's whatever else it may be. I don't know.
Well,
I think Mr. Moran's point was you've got to nail your colours to the mast.
well, you do, but it's in this situation, it's how far do you go, and it's almost this point about continuum. I think was the verb you used this morning, and it's how far do you go between saying this is my case, and how much do I have to particularise that case in relation to each and every CAI?
How much detail do you have to give?
Yes.
Okay. But it's always on the basis that you're establishing a cause of action,
Yes.
and then saying the details as to the loss can be extrapolated.
Well, but yes, but I think the criticism that would still be made against me is that the details of the breach that you would ordinarily expect per Pantelli.
Cannot be extrapolated. That was
Well,
Mr. Moran's
he says they
point.
can't be extrapolated,
Yeah.
and they have. I think he would say they well, I'm not sure what he actually says, and this is something I will come on to.
Okay.
Is where they do ordinarily have to be pleaded, because once you accept that you can have some sort of extrapolation, then why do you have to have full details of particulars in respect of each and every item? Because what's the point of extrapolation? If you take the example of the housing estate, or of 10 houses or 100 houses, if you accept that you can plead a breach in relation to one house, let's say it's a defective design, a missing damp-proof clause, if you accept that you can deal with that case by just looking at the design in house 1, without looking at the design for houses 2, 3, 4 and 5, but just saying, well, it's the same house and it's the same problem, well, isn't that the same issue? You've not
Well, that's
attacked
a
the
defective design issue.
Yes.
But suppose it's a defective design issue in one case,
Yes.
and in another case, it's a lack of proper inspection.
Yes.
So you allow the builders to cover with concrete a steel rod
Yeah.
that wasn't properly fireproof,
Yes.
for example. But you're not saying that extrapolation is possible, or you are?
Well, I am, but in the right case.
Right, okay.
And it comes back to the continuum. If all you did was look at 2 issues and then try to extrapolate over 100 houses and say, well, either they got the steel work wrong or they missed a damp proof, didn't design a damp proof course.
Right.
That's not very convincing. But what if, take the facts of this case, you've investigated 122 issues or more post the judge's order, and you say, well, wherever I look, it's either this, this, or this. There's always something. And there's 2 aspects to this, and I am jumping ahead, but it's on
It's
your
my
mind.
fault.
But it's good to answer it. You say there's one of 2 analyses you can have, at least. The first is, wherever I look, it's always one of 4 things. And I, as a trial judge, am convinced, on the balance of probabilities, that one of those 4 things would have manifested themselves in relation to more CAIs and CVIs in the pool.
Yeah, I understand. I understand what you're saying.
Or the judge might say, and I accept it's better pleaded in my new particulars, but it doesn't matter. Having looked at these 122 CAIs and CVIs, I can see, and having looked at the surrounding evidence, there is a systemic failure by this professional. They didn't properly resource the job, they had no proper system of quality control, no real project management going on. They were all at 6s and 7s. Now that would be something you might call a systemic breach that must, we would say, bite on the pool of variations as much as it bites on the sample. So there's different ways you can look at it, and of course it all depends on the evidence and what you can conclude from the evidence.
And this is the final question, but what you did just is you pointed to each of your fingers to say it's either this or it's either that or it's either the
Yes.
other. And I think if there's a danger, you would accept, would you, that the judge jumps from either A, B, C or D to saying, well, I you know. And I think this is Mr. Moran's point in part, that you're going to open the way to claim saying, look, they're guilty of 4 distinct breaches here, and don't bother to investigate anything else, because even if it's not one of those 4, it's something else in the distance.
But I wouldn't go that far
No,
in this case.
and you'd accept that that's not permissible on an extrapolation.
What I would say is that's not my case here. Goes
Well,
back.
it wouldn't be a representative sample.
Well, quite, and it goes back to mutatis mutandis, and I hope we're not going to decide this on the meaning of mutatis mutandis.
No, okay.
But we say the breach is pleaded at paragraph 175 of the amended particulars of claim will have been committed in relation to the pool as much as they were committed in relation to the sample. We don't go so far as say if those breaches didn't manifest themselves, it would have been something else.
No, I understand. Thank you.
So that takes me to the second part of my submissions, which is what is the point of principle? As this court has made very clear, the issues on this appeal are entirely limited to matters of principle, and this court will not be analysing numerous line items to identify which should be struck out and which should not. But I must emphasise, I don't want this part of my submissions to become like a chambers meeting where we spend half an hour arguing the wording of the motion that everyone's voting on. But I do think it is important to be clear what the point of principle is that the court is ruling upon. And at paragraph 7 of their skeleton argument, that's file 1, tab 2, page 17. Do you have that, my lady?
I do.
Paragraph 7. This appeal raises a single fundamental point of principle. Is it permissible for a party to bring a professional negligence claim by way of extrapolation in the above way? And in the above way seems to hinge on the actual drafting of the pleading and the content of the pleading. So that must mean, well, I think that must mean that however I try and plead my case, it's not going to be valid. But I don't know. But there has to be, it seems, some focus or analysis of the pleading in order to address the point of principle as BDP see it. But we've got to be careful with that, because as soon as you get into the detail of the pleading, there's a risk that we move away from issues of principle and ground the debate in the specific facts of this case.
Well, if it's of any help, I took the point to be the pleading, yes, but really as summarised by paragraph 5 of Mr. Moran's skeleton,
Yes.
1, 2 and 3, which make the points that he's expanded on orally, where he, having shown us how the pleading works, he effectively rests his case on the fact that the pool is unexplored and therefore is incapable as a matter of principle, because it is completely unexplored, of being used in an extrapolated claim. That's in essence, I think, what the point is. Because nobody disputes you can have extrapolation. You both made that plain.
Yes.
So the question here is, can you have extrapolation at the start? And even if you can you have extrapolation of the sort that you are doing?
Yes. I would just add, if you look at his Roman 3 at paragraph 5, he does say, without alleging any systemic breach of contract and or any other facts and matters which could possibly link the two parts of its claim.
Yeah. Well, that's one part.
So,
and then there are the bits in italics, which obviously he's majored on
yeah.
this morning.
Yeah.
I mean, I'm not speaking for myself, to put you off going through the pleading if that's what you'd like to do.
Well,
But at the moment, it seems to me that is that's where we get to.
my lord, I understand that, but I do think it is there were certain parts of the pleading you weren't taken to that show my pleading in a different light to the light which was presented to you. So I will, if I may, take you to those parts. But just on the point of principle, we've heard a lot about Pantelli. But I don't think even BDP, I won't go as far as say Mr. Justice Coulson or Lord Justice Coulson, would say that Pantelli prevents a claimant from pleading a professional negligence claim by way of extrapolation. So then how far can Pantelli really take you? But there that is. Let me come on to the third section of my submissions, the pleaded case. And I'm not going to go over old ground, but I do think, as I say, there are certain passages in the pleading that you weren't taken to that you should be aware of. So if we could take, please, core bundle 3. At page 725. So this is just on the issue of extrapolation, commonality, and the linkage. And you see paragraph 10, which you weren't referred to, it is what Standard Life will rely upon as the basis for its case for extrapolation and drawing inferences It will rely upon the following facts and matters not hitherto disputed by the design team. And then it refers to Costain's assertions that his claims arose from failure by the design team to provide timeless and adequate information. Over the page 2, events cited by Costain its delay substantiation documents as establishing significant entitlement to extension of time. 3, BDP certification and Gleeds assessment of 91 to 93% of Costain's monetary claims was good. And the analysis of Bureau 4, which indicated that Standard Life's own instructions accounted for only 10% of additional varied work. And 2, the negligence of the design team lay behind at least 49% of additional varied work on the project. Just to pick up on one point that Lord Justice Coulson asked earlier, are Bureau 4 defendants to these proceedings? Yes, they're a defendant to the Part A and the Part C claim, but not this claim, the Part B claim.
Right.
So that's the introductory section. The next section I'd ask you to turn to, please, is page 826. And paragraph 182. Another paragraph you weren't taken to, and that's where Standard Life says that it's deducted all costs arising from its own instructions and matters for which the design team is not responsible, so it's deducted 16 million. Having deducted this sum, Standard Life claims the balance from the design team and is supported in this approach by, and then it lists some more points. 1, 2, if you could just note 3 in particular. Standard Life's own analysis, doing the proportionate best it can on the information that is available, reveals their pleaded systemic and recurrent failings by the design team as the dominant or effective cause of the variations analysed and the claims for loss and expense. And then if you look over the page at paragraph 183, you see the word that Mr. Moran said was missing. Absent any explanation from the design team, Standard Life adverts it is fair and reasonable to extrapolate this cause to the remaining variations on the project and the remaining loss and expense certified and paid. And then if you turn over to page 829, I'm sorry, if we could just start at page 828 at the bottom, paragraph 189. It's Standard Life will refer to and rely upon analysis carried out by Bureau 4, and what that indicated.
Sorry, Jonathan.
189. Thank you. And then 190, what the analyses suggest, and that is that the negligent performance of the design team was the cause of the significant volumes of additional varied work on the project. And then it refers to certain clauses of the appointment which required entitled Standard Life to fully coordinated design delivered in accordance with budget and programme together with a competent administration of the building contract. Then 192, in the absence of any acceptable alternative explanation from the design team and with the above provisions in mind, Standard Life will invite the court to draw the reasonable inference that, on the balance of probabilities, all variations, aside from those which arose from non-design team issues, were caused by the negligent performance of the design team. And then we see again at 193, accordingly to give credit for non-design team issues, Standard Life extrapolates the 16.9% of variations caused by non-design team issues in its own analysis to the total value of variations on the project and makes a reasonable deduction of 4.8 million from its claim. So there's a total pot of £28 million of variations, 16% or £4 million was carved out of that before proportional exercise was carried out on the balance. In the context of BDP, that was about 81%. So in my submission, and you had also seen the table at the end which referred to extrapolation. So the pleading does more than what Mr. Moran says it did. It says very clearly why standard life is extrapolating and why it is right to extrapolate and how it intends to do that. And you're also taken to respond.
Can I just make sure
I'm
I
sorry.
understood this? Both paragraph 182 says that it's deducted all costs arising from its own instructions, of which the design team wasn't responsible.
Yes.
And then 193, to give credit for non-design team issues, extrapolate 16.9%. That would therefore include some of the items in the list.
There's actually a double deduction. I'm really reluctant to do this, but it's easiest to see it on a spreadsheet if I may.
Okay, but just
Yeah.
there may be a double deduction, but would that not include an items in that list that we looked at? I think attached to the, I can't remember if it's attached to the further and better particulars, but the one with the colour coding.
Yes. The answer is it should have taken out more from that coloured list than have been at the time of this pleading.
Okay, that I follow. But if
in principle that was the intention, to strip out what was effectively obviously not sustainable, for example, client instructions, therefore they don't arise from design team breaches, but the intention was to strip out that and then have a percentage claim in respect of the rest.
fine, but I just to understand the basic building block,
Yes.
the list
Yes.
that we looked at of variations has stripped out of it, or the intention was at any rate, I mean there may have
Yes.
been a slip between the
Yes.
intention and the doing, but the intention was to strip out of it all those which were not design team, where Standard Life said we'll have gold taps.
Yes, exactly.
But that was the intention.
Yes.
So the intention is that if anybody is looking at any of these other items, if the judge's case management directions stand and we're looking at other items identified by other parties, though from that list, those can't include ones that are already accepted by Standard Life not to be part of the claim. Oh, okay.
The only slight nuance, at least at this stage of the pleading, was the way it was done was first to strip out what was called, I think, stage 1, anchor 1 variations. Can I just check that I use the right phrase? Stage 2, anchor 1, CAIs and CVIs. And what that meant to the layperson, stage 2 was the work above ground, anchor 1 was the anchor tenant, John Lewis. So it was instructions for the anchor tenant, which were accepted not to be the design team's responsibility. So they were stripped out essentially as a line-by-line exercise, and then the extra 4 million that we just looked at, that was done not through a mechanical strip out, but through a percentage application. And just to be clear, what's happened in light of the judge's directions was been a mechanical strip out from the whole list. Actually, there were 3 separate lists, one for each defendant. And that's why the pool has shrunk. So that's the particulars of claims. Can I just go back to the request for further information that you looked at? So there's some additional points to be made on that. And that's in the supplemental bundle at tab 2. And it was response 1 starting at page 50. I should say I completely accept the criticism of the judge that this is not an exercise for the faint-hearted and that the pleading could be better rationalised and simplified. That's what has been done. But we have to work with what we've got for the purposes of this appeal. And I was just going to make a couple of points. At page 51 of that further information, under little e, another paragraph that you weren't taken to, in consequence of the above, standard life avers that it is reasonable and proportionate to prove its case by reference to representative sample. Insofar as the 4 to 6 defendants or any of them have observations to make about standard life's approach, then standard life will consider other approaches or further sampling, if reasonably required, in the light of those observations and the defence is yet to be served. And they said similar at page 54, just above request 2. You see there's a paragraph that starts again. And forgive me if I trespass on matters of detail, but in the context of page 52 of that further information, you'll remember Mr. Moran said, well, they've not even taken the four highest value packages. They didn't look at M&S. They didn't look at M&E, mechanical and electrical. But there is an explanation in the paragraph underneath the list of 6 items that the loss and expense claims associated with M&S, they form part of the claim pleaded at Part C of the particulars of claim. So a large part of that 9.3 million is pursued in Part C. And then the other point, which was explained, was the availability of information. So it said, owing to constraints on the availability of documentation at the start of the sampling process, Standard Life began by analysing the variations in the 4 packages of which we've heard. So I won't go back over the passages in this further information that Mr. Moran took you to, but I thought it was necessary for you to see the whole. There was also a response to Sutton Griffin's further information. And of course, they're no longer a party to this action. I think it's reasonable to assume that everyone was reading these pleadings, even if you weren't a defendant who'd asked for them. And if you could turn, please, to tab 3 at page 76 in the supplemental bundle. It's quite a long response to further information, but I'll just emphasise one point at page 76, because it's quite similar to what you've seen already. About 8 lines down from the top, it starts, whilst no sample can ever be totally representative, Standard Life avers that Schedules 1 to 4 constitute a sample of the performance of both the design team in general and Sutton Griffin in particular that is sufficiently representative to prove Standard Life's case on the balance of probabilities. So that was the pleaded case in terms of linkage, representativeness, extrapolation. Not that I'm going to ask you to do it, but if you were to read the schedules 1 to 4 of the particulars of claim, you would see that the breaches alleged against BDP are all very similar. Mr. Moran tries to explain them as 122 individual, distinct, separate claims, completely unrelated. But what he misses is the coding system of A, B, C, D, and E, which applies across the board. So this is not the sort of cases my lady referred to where you might say, where it's one type of breach here, a different type of breach there, different type of breach somewhere else, and maybe something else in the pool. We're saying what you've seen here is what you'll see there. And this comes back to the point I made earlier to my lady. We made two broad points about BDP's failings on this project. First, given the multiple times that BDP failed in its design, coordination and certification responsibilities, it is likely, on the balance of probabilities, that those failings occurred elsewhere in the project, i.e. in the pool of unanalysed CAIs and CVIs, and in the unanalysed part of the loss and expense claim. Secondly, we say that those failings, along with other surrounding circumstances relating to this project, demonstrate a systemic failure on the part of BDP. In a nutshell, they failed to operate any adequate system of work or quality control and did not properly resource the project. If you want to look at it, that's what's now pleaded at paragraph 86 of the fresh particulars of claim. And if you read the particulars of claim as a whole, the particulars before you, you get a sense in my submission of the complete disarray that BDP was in during the course of the project. There's a lengthy section from paragraph 66 to 174J. I'm just giving those references for your note rather than going to take you through them now. It's a lengthy narrative of the late, uncoordinated, defective and incomplete design information on the 4 packages. So I then come to the criticisms of the list of CAIs and CVIs in the pool. And before I develop that, I should just answer one question that my Lord Justice Birss asked about why there were so many zero value instructions. The answer is that is a complete list of all instructions issued on that project. Contract administrators' instructions don't necessarily have a cost consequence. Some of them can just be instructions to confirm an action that have no consequence. For example, paint the wall using this shade of white, or something like that. Or yes, you can start today, whatever. But there are it's another failing that there was a list of 6,000 instructions. There were 6,000 odd CAIs and CVIs, but only about 3,400 of value.
So why include the others at all?
I've got no answer, but they have to be strict. It's one of the criticisms of Mr. Justice Kerr. It needs to be the pleading needs to be rationalised and simplified.
No, but what was the? It has been, but
yes.
What was the rationale behind it?
Oh, because the original, that list was not a list prepared by Standard Life for the purposes of these proceedings. That was a project document that collated all the instructions. Yes.
So it got used for a purpose it shouldn't have been?
Yes. So it's now been adapted so it's purpose made for this action rather than a different purpose.
Right, okay.
So coming on to that list, it's correct that the extrapolated variations are in a list which is annexed to the pleading, and you've seen extracts from that list already from Mr. Moran. But the case as pleaded did not seek to stop there and claim a percentage of the value of all the CAIs and CVIs in that list. It was about £500,000 of the Stage 2 Anchor 1 CAIs and CVIs. And then there was also the deduction that I mentioned of the 16.9%, about £4.8 million. And just for your note that the 4.8 million is referred to at paragraph 193 of the amended particulars that we looked at earlier. So Standard Life has always accepted that it's necessary to strip out from the pool those instructions where there can be no obviously sustainable claim. And what happened during the hearing before Mr. Justice Kerr was that the defendants identified some choice examples of CAIs or CVIs that were obviously not claimable against them, but which had not been stripped out from the pool. And you see reference to that at paragraphs 102 and 103 of Mr. Justice Kerr's judgment. And that's what led him to the conclusion that there was wheat as well as chaff. So it's page, I don't know if you want to look at those paragraphs of the judgment. It's page 151 behind tab 10 of bundle 1. So he was given choice examples, actually not by BDP, the other two defendants, and the defendants never purported to give the court a comprehensive list.
Well, that wasn't unreasonable.
That wasn't unreasonable.
No. I mean, given the nature of the debate.
Yes, given the nature of the debate, yes. But it was more relevant to ground 3, which is now no longer pursued.
I was going to say, yeah.
But that's the way the case was put. And to some extent, it's similar to the way the case is put before you. You've been shown 1 or 2 CAIs in Schedule 1 and told, look how unique and specific these are. You can't draw any inferences from that. But that's not the case. It's look at 122 and then draw inferences. But that takes me to the overriding point in this case, which is, should BDP be taken to know the case that it has to meet? And in my submission, in considering that question, the court is permitted to take into account the context in which the defendant receives the pleading. It's also entitled to take into account what the defendant can reasonably be expected to know or understand in any event. So, in the context of this case, what can BDP be taken to know and understand from its participation in this project?
Well, I've been waiting for that point because, I mean, part of the context of this is that, on one view, Standard Life don't know anything because they were relying on their professional advisors. BDP know everything because they were the key professional advisor.
I'm sorry if I took too long to get.
No. But I mean that is a point. I mean,
yes.
Mr. Moran would say, "Well, you're reversing the burden of proof." I understand that point, but that is part of the background, isn't it?
Yes.
Employers always have that difficulty when something goes wrong. You've got the contractor with a large claim. You have a professional team. And effectively, as an employer, you are often caught between the two.
Yes.
I mean, that's the pragmatic, realistic position.
Yeah.
So you say, well, you can't ignore the background knowledge.
Can't ignore the background knowledge. Not just the asymmetry between the parties' positions, but also when you read these documents, what should the recipient understand of them? Because it's important to remember, just in the context of the CAI and CVI schedule, this is not a schedule that has come from nowhere. It's a schedule of all the CAIs that BDP itself drafted and issued. They're BDP's own instructions. And it's also a schedule CVIs are different because they're confirmation of verbal instructions. But it's the list is also a schedule of all the CAIs and CVIs that BDP certified for payment. Now, you don't
Just as a point of detail, the CAI is something signed off by BDP.
Yes.
The CVI was something presumably originally provided by Coulson,
Yes.
saying the man on site told me to paint it yellow or
Yes.
whatever. But you say has been approved by BDP for payment,
Yes.
where it leads to a sum of money.
Yes.
Because you accept you don't now have a claim and you're stripping out the ones that are blank or say £0. Yeah.
So in my submission, it's not unreasonable to proceed on the basis that BDP knows or ought to know what the CAIs and CVIs are all about. It's not gobbledygook, as Mr. Moran says. It might be gobbledygook to him, but we can't expect Mr. Moran to speak to his client and take instructions. And we can also proceed on the basis that BDP knows or ought to know why additional sums were certified for payment in respect of those CAIs and CVIs, because it was BDP who did the certification. And we can also proceed on the basis that BDP has access to the CAIs and CVIs and can read them for itself, along with the underlying documents referred to in them. And that's why I would go as far as my Lord Justice Coulson said, BDP actually know more about the CAIs and CVIs than Standard Life. And then I would submit that BDP cannot, as a result, legitimately complain that the CAI and CVI spreadsheet is unintelligible. Now, if I could just give you an example of one CAI so you understand what the material is to work with. And that, if you go back to the supplemental bundle at tab 6, so the first one starts at page 203. And this instruction is one of the items of claim in Schedule 1. And what you can see from the top left, that this it's issued by Building Design Partnership, BDP. Top right, architect's instruction. And then down on the right, you see the instruction number 1620 and the date of the instruction. And then all you get in relation to this CAI is the text or narrative in the middle of the document on the left. Block C, floor screed, scope of works. The drawings listed on the attached BDP issue form are issued for construction. And then you see it signed underneath the BDP. And what they didn't do anywhere is insert anything about cost or approximate costs, even though there's provision for it in the document. And you see in particular at the very bottom. I
venture to suggest that that's not uncommon.
Quite possibly, my lord.
Taking into account some knowledge of the area of law we're in, or indeed practice that we're in.
Absolutely not.
I'm not sure I've ever seen one filled in, but anyway, there it is. This isn't a CVI. You said you were going to take us to a CVI.
No, CAI.
This is a CAI,
Yes, CAI.
because it's a signed instruction.
Yes.
Yeah.
And then all you get over the page at 204 is a drawing issue sheet.
Yeah.
And then somewhere there'll be underlying drawings. But that, from that instruction, Standard Life has developed a case which you see in Schedule 1, and I'll just give you the reference. Core Bundle 3, tab 16, page 873, a claim for inaccurate, incomplete and uncoordinated design.
Sorry, Core Bundle 3, page
873. And there's a little collection of other CAIs here. I don't propose to take you through them, but that's what we have, Standard Life has, to work with. It's not the case that these instructions are very detailed and tell you a whole story about why they're being made. They don't even tell you whether they give rise to additional work or not.
But it does give you in this schedule the value of the CAIs.
Yes. So
where would they obtain that from?
So these instructions would have been formed the basis of claims for payment by causation, and then the two steps happen, and I'm not sure in which order. It shouldn't matter. BDP certify in principle that the causation, the contractor, is entitled to additional money, and Gleeds, the quantity surveyor, will value the additional cost. Okay. And that figure then gets either, I don't know exactly what happened, but would feature, then it features in the schedule one way or the other.
So that would be new to BDP.
The number?
Yes, but not the nature of the claim, that's what you're saying.
Yeah. Well,
and you're saying the number isn't new because they would have, well, the number is, they have certified.
Yes, it's not new in the sense that the first time they see the number is when they receive the pleading. It's new in the sense that they don't generate that number at the time. Yeah. So, why am I showing you this? One, so you can understand what work has to be done to generate a claim in relation to any CAI or CVI as well. But two, because it is relevant to assessing what is an appropriate sample to plead a case by reference to, because the level of documentation and information available to the pleader should help decide what is a proportionate approach. And I should just make clear that this issue about the level of information in the instructions is not something that we're raising ex post facto now that we're in court. It's something that Standard Life raised during the course of the development. You don't have all the documents before you because we obviously kept the appeal bundle to a minimum, but what you do have is paragraphs 11 and 12 of Mr. Justice Kerr's judgment. Which is Bundle 1, Tab 10, page 129. And you see how at paragraph 11, Mr. Justice Kerr recorded how Standard Life produced to him contemporary documents showing Standard Life's expressions of dissatisfaction with the design team's performance, especially BDP, and refers to various meetings. But then you see at paragraph 12, he quotes from a letter of the 17th of May, specifically complaining about the drafting of the CAIs. And that's a taster of why Standard Life pleads a claim for inadequate record keeping. That's not really something of importance for today, the fact that is claimed. But I think my Lord Mr. Justice Coulson picked up earlier, spotted the claim for inadequate record keeping, but that's some of the context to that. So then finally on the pleading, I should just deal with extrapolated loss and expense, because again, BDP haven't quite properly or correctly summarised the pleaded case, because they omit to tell you that before carrying out any extrapolation in respect of loss and expense, Standard Life had extracted out from the loss and expense account those heads of loss or parts of heads of loss which could not be pursued against the design team because, for example, they related to client variations or tenant variations. And you see that as a starting point. If you could go please to core bundle 3. At page 832. Start at paragraph 196. Again, these are paragraphs that you weren't taken to. In assessing Standard Life's entitlement to loss and expense, please produce an assessment dated the 25th of April and subsequently a final account. And then they say that Standard Life has been given no cause to doubt that it claims the amount which it paid to Coulson for contractors' loss and expense in full, less claims or parts of claims which the design team was not responsible. And then it makes a specific point at paragraph 198, which I won't trouble the court with now, and that feeds into the point at paragraph 200, where it says essentially there's four years or periods of delay. Standard Life in this pleading was only pursuing claims in respect of years 1 and year 3, but not 2 and 4. I might have got that the wrong way around. I've got that the wrong way around. They're only pursuing claims for years 2 and 4, not years 1 and 3.
So, Mr. Selby, if you're able to plead in paragraph 197 that this final account was less claims or parts of claims for which the design team were not responsible,
Yes.
how were you able to say that if this is an extrapolation case?
So, can I take you to Annex 13, because that might be easier in about 1 minute,
Yes,
and then I can. But there's essentially a list of heads of claim, and Standard Life was able to look at the heads of claim. I think it might have been 13 or 20, something like that number, and look at them and say, oh no, that can't be to do with the design team. It's something else.
All right.
So they work backwards.
All right.
But just to complete, while we're on this page,
Yes, of course.
you see at paragraph 201, see Annex 14 here too, for a full explanation and breakdown of the Coulson claims, or parts of the same which are omitted from the claim on the above bases. After those omissions, the total contractor's loss and expense occasioned by the design team amounts to 10.7 million, which is split between the 6 million, what's called conventional claim, and the 4.7 million or 4.6 million of extrapolated claim, which was 3.7 against BDP. So, if I could just take you to, so the headline is the best part of £11.2 million was stripped out of the loss and expense account before any claim was made against these defendants. It wasn't just we want everything in that, a percentage of everything in that pool.
And that was on the basis that someone had made an assessment that BDP could not be responsible for that particular portion.
Head of loss. Yeah.
Yes. Oh, well, head of loss rather than portion of the money. So the nature. They could not be responsible for the nature rather than the proportion of the loss.
My lady, it might help if I explain the way the loss and expense account works. There are different heads of claim.
Yeah.
So the obvious one, which you saw reference to, is prolongation. That's Costain's extended, the cost of Costain itself being on site longer, site cabins, management, whatever. But then there's a number of other claims that might be made for individual works contractors. So the subcontractor will put in a claim saying, well, I was on site for longer and I want my additional costs. So that might get claim, that might be called claim number 22, subcontractor act. Then there's claim number 23, another subcontractor, and so on. And then you get other heads of claim. So what Standard Life did for this exercise, say, well, claim number X, that can't be design team responsibility. We know that was to do with something else.
So that was the nature of the claim, that you could just say straight away, this cannot fall through into BDP's lap.
Yes, and what they also did for prolongation was because we had the Gleeds document, which divided the claims into 4 years, and we knew what was said by Gleeds to be the causes of delay in relation to those 4 years, that 2 of those years were not design team responsibility.
Yeah, okay.
And that's why they could then divide up the prolongation claim. So then you get to Annex 14, which explains it in some more detail at page 850 of Bundle 3. And I don't propose to take you through that in any detail, but there they set out which heads of claim from the loss and expense claim have been stripped out, either in whole or in part. And how that stripping out has been done, where there's been a partial. It goes through a few pages. It might be something you want to read at your leisure. It might not be. Doesn't matter. So that was the case, and then just asking the question: does BDP know the case it has to meet? Yes. BDP can read. It can read the whole pleading and all the annexes. And that case is that once the court finds either that BDP's design failings occurred elsewhere in the project or a systemic failure on the part of BDP, then the court should find that those failings caused loss and expense as well as CAIs and CVIs. And it's then for the court to assess the quantum of that loss and expense. Now, I should just say the issues concerning loss and expense are now somewhat academic, because in the fresh particulars of claim there is no extrapolation element. In light of the judge's order, Standard Life has investigated it fully and worked out a case that can be a more conventional claim, but for almost exactly the same amount of money, give or take about £100,000. We're doing quite well, that's all I was checking for.
Good.
So I then come to my fourth section of my submissions. Does Standard Life's pleaded case on extrapolation fall foul of CPR Rule 3.4, brackets 2? And there seem to be various aspects to this question, each of which I will address in turn. Does BDP know the case it has to meet? Does the extrapolated claim represent an impossible agenda?
Hang on.
Oh,
If these are your headings for what you're going to submit?
You're absolutely right, my lord.
So first, does BDP what?
Does BDP know the case it has to meet?
Yeah.
Does the extrapolated claim represent an impossible agenda for trial? Does the extrapolated claim place unjustifiable and unfair commercial pressure on BDP? I should just touch on this point, whether extrapolation can be used in professional negligence claims. Whether proportionality is
Wait a minute.
I'm sorry, I'm not watching your pen, forgive me.
You're not. First rule.
I failed.
Your fourth point, which you just sneaked in, was can extrapolation
be used in professional negligence claims?
Yeah.
Whether proportionality is a relevant consideration. Floodgates argument. The similar fact evidence point. And then the final question asked by the judge, which is the inference sought so manifestly impermissible that no reasonable trial judge could draw it?
I'll make that 8.
So do I, and it seems to be that there's some overlap between those.
Could well be.
Yeah. Okay.
In terms of does BDP know the case it has to meet, I've really addressed you on that question already by reference to the pleadings. I submit that BDP does know the case it has to meet. I'll give you some paragraph references to the judgment and then just take you to one for now. I adopt paragraphs 104, 110 to 112, and 135 of the judgment. But for now, could I just take you to paragraph 110, please? Which is at page, bundle 1, tab 10, page 152. Now, just in dealing with a particular criticism about the judge failing to follow the two-stage test, as per Liverpool Victoria, I submit that's not correct. The judge clearly did approach the question in 2 stages. He found that the defendants do know the case they have to meet. And those are the paragraph references I've given you. Ergo, the claim did not fall foul of CPR Rule 3.4 brackets 2.
So that's his finding of fact.
That's his finding. Then what he went on to do, for example, where at paragraph 109, he made the finding that the vice of the pleading is the more venial one, of artificially inflating the claim by including losses based on impermissible inferences. That's indeed a fault, but not one that comes close to an abuse of the court's process. So his directions were case management directions. They weren't a situation where the judge finds abuse and then considers what is the proportionate sanction. Should I strike out or should I take some other course? So that's what I had to say on does BDP know the case it has to meet. Then on the question of agenda for trial, it's said against me that the pleaded extrapolation claim represents an impossible agenda for trial. In my submission, that is not so. the agenda for trial will be that the court has to try standardised claims on each of the CAIs and CVIs in the sample. I'll just address you on the CAIs and CVIs and not loss and expense, but it's the same idea. It will then have to ask whether any inferences can safely be drawn from the sample analysed so as to permit any extrapolation into the pool. If the court finds it's safe to extrapolate, then the court will have to decide how it will extrapolate. In my submission, that's not an impossible agenda for trial at all. It's similar to the agenda that Judge Davies had to grapple with in aiming. I would also say that it's BDP's position that represents an impossible agenda for trial. Because if you take BDP's case to its logical conclusion, what Standard Life must do is analyse individual claims in relation to hundreds or thousands of CAIs and CVIs. And you'll have seen the breakdown of the CAIs and CVIs in my skeleton. There's something like, well, let me give you a precise number. So it's paragraph 18 of my skeleton, page 95 of bundle 1. Tab 7. Now there's something like 2,700 instructions with a value less than £5,000. Now let's assume that Standard Life were to analyse all these instructions. And let's say we're only to pursue a claim for 100, 200, 300. That of itself, on top of the already pleaded variations, is an impossible agenda for trial. I can't imagine any High Court judge wanting to try so many instructions, especially of such modest value. Now, Mr. Moran would say, well, if they're of such modest value, don't plead a claim in relation to them. But between them, they add up to a significant sum. So why should a claimant just abandon them? Why shouldn't the claimant seek to persuade the court? Might accept it, might not accept it. But seek to persuade the court, you can safely extrapolate into that pool as a proportionate way of dealing with its claims. As the judge found, there is a pressing need for trial by sample. That's paragraph 142 of the judgment. In this context, you may have picked up from the judgment the argument raised below that county court claims worth in the region of £10,000 are routinely investigated and pleaded. But that's a completely different kettle of fish, because that relates to multiple claims between multiple litigants relating to all sorts of matters, from road traffic accidents, housing claims, personal injuries, family matters, and so on. But as the judge found at paragraph 129 of the judgment, for the court to try all the CAIs and CVIs in dispute in this case would allocate disproportionate court resources to a single claim. In short, there is only so much time that these parties and this dispute can require of a High Court judge. So
Well, it's less the resources and more the disproportionate costs that will be incurred.
well,
If you tried out every CVI or CAI, the trial would last a year.
well,
Then the case would become even more all about the costs than it doubtless already is.
Yeah. But I would say it's still, the court's resources are still relevant because, well, you have been head of the TCC, but I'd have thought any head of the TCC would not want one of their judges to be detained on a case for a year.
No.
So then I come to unfair commercial pressure, where it said that the extrapolated claim places totally unjustifiable and unfair commercial pressure on BDP and its insurers. Just for your note, I deal with that point at paragraphs 59 to 61 of my skeleton. In my submission, this complaint should be rejected. Indeed, an equivalent complaint would likely have been made had Standard Life pleaded out a case on each and every CAI and CVI in the pool. They would no doubt, as my Lord Justice Coulson just said, it all becomes all about the costs. So if Standard Life came to the court saying, I've investigated everything in the pool, and here's my pleaded case about all the CAIs and CVIs, and then the case management information sheet, or even in its cost budget, it says, I've spent already £2 million, £3 million, £4 million. Then you can imagine BDP crying foul. They spent far too much money on this case already. I'm under too much pressure to settle because of the cost. And they would no doubt go to the court and make applications for cost orders and cost management orders. I'll come back to that. But let's get real about commercial pressure here. BDP is a substantial commercial organisation backed by insurers and represented by leading solicitors. To suggest that the extrapolated element of this claim puts BDP under any greater pressure than any other professional negligence claim of similar value would is difficult to believe. There's no question of inequality of arms. So then I come to the point that seems to be simmering, but isn't quite made, or maybe is, but who knows, about whether extrapolation can be used in professional negligence claims. Seems to be accepted in principle, but it's not clear how far that acceptance goes. But in my submission, there's nothing so special about claims against professionals in this context. Usually, the justification for giving professional negligence claims particular treatment is that the professional's reputation is at stake. But in that regard, I make 3 points. First, Amy's reputation as a highways maintenance contractor was at stake, but that didn't prevent an extrapolation being considered in Amy and Cumbria. Likewise, Merritt's reputation as a pipework contractor was at stake in ICI and Merritt. And in both those cases, there was a lot at stake, not just reputationally, in both Amy and ICI. And of course, there's also the big question of costs. Secondly, on the subject of reputation, in my submission, if 122 sets of breaches are proven in respect of the 4 packages, BDP's reputation will not be materially worsened by a finding in Standard Life's favour on the extrapolation case also. Indeed, you might take the view that after 122 findings of breach, any further findings against BDP would simply amount to kicking someone when they are down. Or I think Lord Justice Birss said there comes a point on the continuum where the judge says, enough. Thirdly, in my submission, there is no reason why professionals should be given special treatment in this context. Indeed, it's hard to see how under the common law the court could create or adopt a special rule for professionals in relation to extrapolation. take an example of fraud. Where fraud is alleged, reputations are also at stake. So would that mean extrapolation is impermissible in fraud claims also? In my submission, no. The better answer is to come back to the key question of whether the claimant has discharged the burden of proof. And the already well-established rule that the more serious the allegation, the more cogent the evidence will have to be before a claimant proves its case on the balance of probabilities. So then I come to the point about, well, how do you deal with a Part 20 claim? What if BDP wants to make a Part 20 claim? Well, so far it hasn't, and it hasn't said that it wants to make a Part 20 claim. But if it wants to make a Part 20 claim, it can. And what it's got to do is produce its own extrapolation claim. Now, it's difficult to be precise because we don't know who they want to make their Part 20 claim against. But if, for example, they've subcontracted every element of their design, their architectural function, well, it's just a straight pass-through. If what they're doing is making a Part 20 claim against some consultants, but not others, well, if it's CJP or Sutton Griffin, that claim was already pleaded against them anyway in this case. So again, that could be passed through. If it's a Part 20 claim against someone else, then BDP has got to do its own analysis. It looks at the 122 variations in the sample, pleaded against it. And then if it finds commonality in relation to the Part 20 defendant, it can plead out its case on the 122, or the subset of the 122, and then it can run a case of equivalent extrapolation in the same way that the claimant pleads a case of extrapolation against it. But you can't be too prescriptive because you don't know who they are looking to Part 20 against. So then I come to probably what is Mr. Moran's biggest point, the relevance of proportionality, where he says issues of proportionality are not relevant at the pleading stage. Well, okay, let's go to paragraph 75 of your skeleton. That's bundle 1, tab 2, page 33.
What paragraph again?
Paragraph 75.
75.
It is not accepted that issues of proportionality are relevant at the pleading stage. In my submission, that can't be right. The pleading sets the tone for the whole litigation. It directs what is required for disclosure, witness statements, and expert reports. And of course, it sets the agenda for trial. If you want authority for that, I can give you that. For example, you see that in Pantelli, paragraph 11. That if the claimant doesn't seek to plead its case proportionately, the proceedings set off on the wrong foot. And it would be remarkable if the overriding objective didn't apply to the pleading stage, especially when dealing with a case justly and at proportionate cost includes saving expense, dealing with cases in ways which are proportionate to the amount of money involved, ensuring that the case is dealt with expeditiously, and allotting an appropriate share of the court's resources to any given case. That's CPR 1.1 brackets 2. Then CPR Rule 1.3 requires the parties to help the court to further the overriding objective. Well, what better way can a party help the court further the overriding objective by pleading its case in a proportionate manner? And finally, CPR, well, 2 more points. CPR Rule 1.2 mandates the court to give effect to the overriding objective when exercising any power given to it or when interpreting the rules. So that includes the power to strike out under Rule 3.4. And then Rule 1.4 brackets 2 brackets C provides that active case management includes deciding promptly which issues need full investigation and trial, and accordingly disposing summarily of the others. You can't come much more promptly than at the pleading stage. Now, it's slightly strange that lots of us have referred to Pantelli without actually going to Pantelli. But perhaps if I could just take you to Pantelli and then take to the decision of Mr. Justice Aikenhead that followed it.
This is on proportionality, is it?
Yes. So Pantelli is at tab 4 of the authorities bundle. And of course, Pantelli was a case where no particulars of negligence were alleged other than some vague and unspecific allegations and damages to the sort of £300,000. And the claimant sought further details of the counterclaim, and by an agreed unless order, the defendant was to apply to amend its counterclaim and provide proper particulars in which the counterclaim would be struck out. And the issue before the court was whether the pleading complied with the unless order, because there was an application that the allegations of professional negligence should be struck out. And at paragraph 11 is where the court made its finding at page 44 about the pleading. And here you see the gravamen of it, which is the first sentence in my submission. And I should be careful because Lord Justice Coulson drafted this, but in my submission, the key point is the second sentence of paragraph 11, where the particulars of claim contain an allegation of breach of contract and or negligence. It must be pleaded in such a way as to allow the defendant to know the case it has to meet. And what follows is what my learned friend relies upon, about saying what the defendant failed to do and should have done, and so on. And then, again, just for context, carries on, they're required for proper witness statements and, if necessary, an expert's report, and so on. And then over the page, page 45, Lord Justice Coulson said at paragraph 17 about how it's standard practice that where an allegation of professional negligence is to be pleaded, that allegation must be supported in writing by a relevant professional with the necessary expertise. So then what happened was ACD and overall came along, which is at tab 5.
Sorry, I thought we'd gone to this for proportionality.
I'm getting there, slowly, forgive me.
Right. Pantelli on its face has nothing to do with proportionality. That wasn't an issue in the case.
No.
Right, so then we're coming to...
tab 5, ACD and overall. The facts in a nutshell, ACD were landscape architects who produced a landscape and visual impact assessment for the purposes of a planning appeal. That assessment was not a full assessment and the planning appeal was dismissed. ACD sued its client overall for outstanding fees, overall counterclaimed alleging that ACD had been negligent in failing to provide a full assessment. ACD applied to strike out the counterclaim on the basis that it was not supported by expert evidence at the time it was pleaded, citing Pantelli. What actually happened was, before the application was heard, Overall produced a draft expert report in support of its case, but the issue concerning Overall's failure to obtain an expert report was still considered because it was relevant to the cost of the application. So it was in that context that Mr. Justice Aikenhead considered Pantelli and the requirement in Pantelli to produce an expert report. And he did that at paragraph 16.
The sort of requirement to produce an expert's report, it's an expert saying that Mr. X has not satisfied the standard to be expected of that particular profession, about which the court knows nothing.
Yeah.
That's the it's not a technical requirement, it is simply a basic need, because unless there is that, there's no there's no basis, or there's no proper basis for the allegation.
Yes, that's exactly that. You have to have a proper basis for making the allegation which you're making.
Yeah.
And Judge Aikenhead addressed that at paragraph 16, at page 54. At A, he said that the requirement is not expressed to, Pantelli is not expressed to and does not lay down an immutable rule of practice, that in those circumstances no pleading can be put forward which pleads professional negligence unless and until the party pleading has secured supporting expert evidence. But then at D, he said, where there are explanations as to why the party pleading professional negligence has not or has not yet acquired expert corroboration of its allegations of professional negligence, the court can look at those reasons in making up its mind as to what is an appropriate course. Thus, it may be legitimate for the court to bear in mind that it is disproportionate, cost-wise, for expert evidence to be secured at a very early stage in this case, particularly where the amounts in issue may be small or where there is a sensible prospect of mediation or other amicable resolution. This, in my judgment, gives effect to the overriding objective. So, after a long way round, what this tells you in my submission is it's absolutely right to be looking at the overriding objective at pleading stage. And if you just take the case against me to its conclusion, it said to me, it's wrong that I've not pleaded out a full case on duty, breach and loss in respect of each and every CAI and CVR. Well, I say I can give reasons why I've not done that at stage 1 of the analysis. And the particular reason for these purposes is disproportionate for me to do so. And it's disproportionate for the court to have to be burdened with all those claims. So what I'm going to do is plead a case by reference to extrapolation. And I'll take my chances. It might be upheld, it might be rejected. But that is a proportionate cause for me to pursue my civil rights.
So you say what? You say proportionality is therefore relevant. Relevant at the first stage of the 2-stage test?
Yes. Because the court has to ask, is this a proportionate pleading? Or put it another way, when considering whether a pleading complies with Part 16, or the requirement that a defendant must understand the case it has to meet, it's entitled to consider whether that case has been put proportionately. And just going back to a point I made earlier about the costs, I adopt paragraph 127 of the judgment, which is at tab 10, page 154. paragraph 127, the judge rejected the defendant's dismissal of proportionality as a concern. It is a very real concern. Mr. Selby may well be right, I like those words, that they would have complained of disproportionality as Standard Life spent millions of pounds analysing every variation and delay notice and then unleashed an avalanche of documents. And that goes to the point I made earlier about cost management orders and so on. The TCC is well experienced of these sorts of complaints happening. Lord Justice Coulson gave one of the seminal decisions on the point in CIP and Galliford Try about what to do with costs incurred. We don't need to go to that, and it's not in the bundle, but that was an example where serious complaints were made about what had been incurred by the claimant at an early stage. So then I come to the floodgates argument. And for every time you ever hear a floodgates argument, it's rare that you ever see the floodgates open. But really, is this a floodgates case? Before you even can try and open the floodgates, you've got to have spent, in this case, something like £950,000 on analysing 167 CAIs and CBIs. That was the evidence before the judge about what had been spent to plead the Part B particulars of claim. And then you'd have to spend even more money because in light of Mr. Justice Kerr's order, an additional 160 to 210 CAIs had to be analysed. And that's before you look at the delay notices. That's hardly an invitation to potential claimants to plead extrapolation claims.
So this can be dealt with by case management directions.
Absolutely. Because the claimant still needs to plead a sufficiently representative sample. It's not the example Mr. Moran gave of a claimant coming to court and saying, I've looked at one defect and this is what I found, and extrapolate that to 100 defects in this building. The court allowed that, which it wouldn't, then yes, maybe there's a crazy floodgate situation, but not here. You've still got to plead a representative sample and a convincing case that you can extrapolate. So, I don't think I need to say more about floodgates. Similar fact evidence. Mr. Moran's right. He's right in the sense that neither party before Mr. Justice Kerr relied on similar fact evidence as being relevant to their position on the application. And I'm not really relying on it now, and nor is Mr. Moran relying on it now. The judge refers to it at paragraphs 89, 90, and 117 of his judgment. It might be worth looking at least 89 and 90 at page 143 behind tab 10. So 89 is where the judge refers to law on similar fact evidence, and all the judge really said at 90 is the possibility of some similar fact evidence of repeated negligence or repeated causation of loss being admitted at trial is a relevant factor here, given these defendants' invitations to court to deal on a summary basis with the primary claim. Now, in my submission, there's nothing controversial with that. He's taking into account what might emerge by the time of trial. but also the reference to similar fact evidence also demonstrates the willingness of the court to draw inferences from primary facts where it is appropriate to do so. Always has to be satisfied it's appropriate to do so, but you don't have to prove everything by reference to primary facts. So then I come to, I think what was the final of the 8 questions, is the inference sought so manifestly impermissible that no reasonable trial judge could draw it? Now, I'm not sure how far the court is willing to go on this point because we're only talking about issues of principle rather than issues of detail. But given that my learned friend said things like, this is apple and oranges and so on, I should at least give you a flavour in my submission of why this is an inference that a reasonable trial judge could draw.
Well, you might be able to deal with it by saying, I accept the proposition. You cannot compare apples and oranges, but that isn't such a case as this.
That's my headline.
Do you need to do anything more than that?
Well, perhaps if it helps the court, I could just explain briefly why.
Yes. Yeah.
The first point is, of course, as I explained to you when I went through the pleading, we've stripped out claims that are obviously unsustainable. But then on the question of connection, I don't accept that it's apples and oranges in terms of what's in the sample and what's in the pool. There's a number of reasons for that. First is the basic connection, that these are all CAIs and CVIs on the same project concerning work by the same design team using the same work systems and processes. This is not the sort of case which the judge alluded to in his judgment where we're trying to prove a negligent failure to detect dry rot in a residential development in Bermondsey by proving a negligent failure to detect dangerous combustible cladding in an office block in Birkenhead. We've already looked at the pleaded case where you see the same breaches on multiple occasions. That's multiple breaches of lateness, inaccurate design, incomplete design, and a lack of coordination. And what we'll be saying to the court is, if the architects were struggling to produce appropriate and coordinated information timelessly for one package, it's more than likely that the same was true for other packages. And in this connection, it's important to remember that the work packages are intimately connected. They're not separate, unrelated packages. The works packages, they reflected Costain's procurement. They didn't reflect the deliverables required of BDP. So it's not the case that the design information for one works package is completely separate and distinct from the design information for other works packages. Deliverables required of BDP were required for a number of work packages. Examples include building elevations, general arrangement drawings, and internal layout drawings, so that defects or delay in a particular design deliverable could affect multiple packages. If I can just give you one example to give that some colour. The design of the brickwork and blockwork package was dependent on the architectural design of the building elevations, because that would show the window locations. And so then you know where your brickwork and your blockwork is to go, and how much brick and blockwork you need. And it's also dependent on the setting out of the secondary steelwork, because that tells you where the posts and the brackets will go. And so you see how building elevations and setting out are core matters of architectural design which underpin many work packages. another example, the design of the carpentry and joinery package, particularly in relation to doors, was dependent on the floor finishes determined by the residential fit-out package. The size and the height of the doors was contingent upon the level of the floor finishes. There are other points. The development's not a particularly heterogeneous, genius or complicated project. It involved replicating the same sorts of design features across multiple blocks. I've already said how the analysis of the pool and other evidence will demonstrate how BDP was in disarray. We'd also say that the sheer number of CAIs and CVIs demonstrates a lack of control. And you've already heard me about the systemic breaches. The other point, of course, is the point that came up in debate with my learned friend Mr. Moran earlier. You can plead a positive case. But what we don't have is a positive case. For example, BDP doesn't advance any sort of lone wolf defence along the lines of, well, all the breaches alleged are the responsibility of a particular individual or set of individuals. We had a completely different team working on all the other packages. So it's unsafe to draw the inference. In fact, there's no positive case. They could also say, well, we've analysed another 100 CAIs and CVIs in the pool. They're all client instructions. You've missed out all your client instructions. In fact, this case with this project ran so over budget because the client was always issuing instructions. They could say that, but they don't. And what we say is the lack of a positive case supports the inference. I might be getting on to too much detail, but BDP had duties of reporting to Standard Life. I can take you through duties if necessary, but they had duties of reporting. Standard Life was complaining during the course of the project about the conduct of the design process. And we say in that situation also, there's a positive obligation for BDP to deal with those criticisms and explain what's going on. And we would rely on their failure to do so, again, as supporting the inference. I'd also add that we now have a representative sample. We say what the court has, certainly following Mr. Justice Kerr's order, it is a much more representative sample, spanning a number of work packages, an additional, a total of 14 works packages, and that's an analysis of 277 CAIs and CVIs, with a total value of £12.9 million from a pool of £17 million.
Sorry, where's that?
But the best place to get that data is the sheet that was provided yesterday at the back of my pleading. I think
So nothing to. So this is yesterday's kit.
Yesterday's kit.
Right. And is this different from the defendant's sheet?
It's got similar numbers but extra numbers. So the before, and if you remember, the defendant's sheet had a middle column. It went through 3 rounds of pleading. So we've missed out the middle column.
So when this talks about the amended particulars of claim, that's the one we've been looking at.
For the judge, yes.
So this is comparing the one before the judge with the October one.
Yes, served on Friday.
Yeah, and so what are we looking at?
So if I just work through each of the rows, the total pool, in other words, the pool into which we extrapolate, is reduced from 23.6 million to 17 million. So that's by virtue of the stripping out of the CAIs and CVIs that aren't couldn't possibly be properly claimable. then the value of CAIs and CVIs analysed has gone up from 3.7 million to 12.9 million. And so then you have the consequence of that, the value not analysed, much reduced. It's gone down from 19.9 to 4.1 million. Then you have the number of CAIs and CVIs analysed. That's gone up from 160.
That was the figure you were giving us, yeah?
Yes, with 277. And then what we've got is a split. This just refers to the design team as a whole. So you'll recognise the 122 number from the pleading that we've been looking at. That went up to 174 against the design team as a whole. And then the next few numbers you will recognise from Mr. Moran's sheet. The conventional claim for CAIs has gone up from 3.02 million to 4.1 million. The extrapolated claim has decreased markedly from 16 million to 1.27. And the total claim for CAIs and CVIs has reduced from 19.3 to 5.27 million. And then you see that loss and expense no longer relies on extrapolation. And the other claims, professional fees and rental income, they've changed, but they're for different reasons that the court doesn't need to concern itself with. And then you've got the total claim that is now made against BDP. So what I say is, we now have a representative sample from which the court should be much more comfortable about drawing inferences, should it think it proper to do so.
The one figure on Mr. Moran's sheet, there's the 19 million odd.
Yes.
Which is the alternative case, i.e. without the extrapolation. Where's that here?
Oh, what the bottom right of Mr. Moran's sheet, that 19 million?
Yeah.
I think that's the one I've got at 20.4 at the bottom right. I can check what. Oh no.
No, the 20.4 is his 20.4.
Sorry, you're right. I don't have the alternative case in this document. You'd have to do some addition.
It's not the total of these other figures.
It would be the total of 433,000. I'm doing this on the hoop. I can check and.
Okay, all right. Well,
I do agree, Mr. Moran.
But I mean, it was the comparison with that which showed that the amount of the entirely extrapolated claim had come down to 1.2 something, which you agree because you got your 1.27.
Yes.
So the figure looks to be right.
Yes.
Right. Okay. Fine.
So that's everything I have to say on connection and why it's not apples and oranges.
Okay.
There's probably more I could do, but it's probably overdoing it.
Well, we're going into the particulars rather than the principles, aren't we?
Absolutely.
So it's 4:15 now. Where are you in terms of your submissions?
Well, my lady, I think, famous last words, I'm at the end. I had another section, but that was to deal with ground 3.
Which is gone.
Gone.
Yeah, okay. So just forgive me, if you will, for a moment. Mr. Moran, have you got a response?
Yes, which I would estimate would take half an hour,
Right.
which I'd be happy to do now, or to start with, or come back tomorrow morning to do.
Speaking for myself, I think tomorrow morning, subject to my Lord's convenience. Is that okay? Yes. And thank you, Mr. Moran. What I'm going to do, Mr. Selby, is I'm going to give you the same indulgence as I did to Mr. Moran. If there's anything overnight which, on reflection, you think you do need to restate or bring to our attention, so be it.
Thank you.
All right. So it looks very much as though we will finish tomorrow morning around about 11:30 without putting any pressure. And we've obviously got the day set aside, but that will bring it to a conclusion so far as the submissions are concerned, obviously.
My lady, I should just ask if there are any questions which the tribunal has that you feel I've not addressed and I should address overnight.
Well, it might be that we want overnight submissions. No,
Very well, of course.
I think we have asked questions as we've gone along, as we did with
Yeah.
Mr. Moran. But you can rest assured that, likewise for Mr. Moran, if there's something we want him to deal with before he starts his response, we'll give him that opportunity.
Thanks.
Thank you very much. So 10:30. 10:30 tomorrow, please.
All right.